Excuse me, I have a petition for a quick time. Just trying to remind the shut off on the cell phone, that I find it nice to put them on vibrating mode. We can start in about 2 or 3 minutes. All right, thank you. You're welcome, sir. All right. All persons having business before the Honorable Associate Judge, down presiding of the District of Columbia Court of Appeal. Draw near and give your attention. God to the United States and His Honorable Court. This Honorable Court, now the session, please be seated and come to order.
Good morning, everybody, and welcome to the District of Columbia Court of Appeals. We have 3 cases on this morning's calendar. We'll begin with the consolidated cases with 23 AA 363, Butler versus DC Department of Human Services versus Angela Butler, 23 AA 384, which is DC Department of Human Services versus Gladys Hill, and 23 AA 385, DC Department of Human Services versus AE. And there are 2 others with similar numbers, which you all know. So, counsel.
Good morning and may it please the court. Jeremy Girton on behalf of DHS, and I'd like to reserve 2 minutes for rebuttal. The Public Assistance Act creates a narrow mechanism for correcting errors of law contained in a departmental policy, construction, or interpretation of a relevant statute or regulation. The orders before the court today do not attempt to correct any erroneous legal interpretation by DHS. Instead, they impose a vague, sweeping mandate to improve DHS's computer system without any evidence that that system is fundamentally flawed. That kind of relief may only be issued by a court using its equitable powers, and this court should vacate the orders below. I welcome the court's questions on any of the issues in this case, but I think it makes sense to start with the definition of the policy that the ALJs thought they were enjoining here.
Can we, before we get to it, I mean, it seems to me that there's a predicate question of whether or not DHS has done enough to preserve its objections here. And can we just focus on the Harrison case maybe? Because in Harrison, my recollection is there's a written motion filed in February asking for an order to basically correct their policy. It doesn't mention computers, I don't think, in the motion, but correct their illegal policy of issuing late payments. That's served on counsel for DHS. The ALJ then issues a proposed order, maybe on February 28th, which says, okay, I'm going to issue this order that includes the computer language, you know, fix your computers, quit issuing late payments. That's served on counsel for DHS. And then in early March, the ALJ eventually enters that order, and it's still a couple months before DHS makes any objection, including at the Hill hearing, where I understand DHS was not counsel, but they said, yeah, go ahead and enter this order. And they seem to have notice of what was coming down the pipeline. So like in light of all of that history, why would we hear DHS complain about this order for the first time to us on appeal when they didn't seem to be saying boo in front of the ALJ?
So I think it is perfectly fair to criticize the agency for not saying more and more quickly, but I think there are a few reasons for that. The first of which is that these hearings are designed to be problem-solving hearings. They're not designed to be adversarial in the same way we think of with a judicial proceeding. And I think you can see that from the records in many of these cases, including, I think a good example is in Butler's case, where she came with a hearing request about SNAP benefits. and at the first hearing raised 6 other issues related to other benefits programs. And the non-attorney representative from DHS said, you know, we'll look at all of those issues and try to solve your problem here. So I think that was what the representatives were focused on when these orders were being asked for. I do think it's important to note that the motion for the order in Harrison's case described the policy fundamentally differently than what the ALJs claimed that the policy was. The motion in Harrison's case said that the agency had a policy of not timely processing recertification documents and that was delaying people's payments. That is a different policy than the one that their brief describes the policy as now, which is once the agency has identified a problem, it either refuses to fix it or fails to use manual solutions to come to get people the benefits they need. I think those are very different policies, and it wasn't clear what policy was at issue because DHS has never understood itself to have a policy that was implicated by any of these cases. So I think that the representatives were really focused on solving the problem in front of them and not on preserving legal arguments about these motions. And I don't think that they always had complete notice because, for example, in Ebron and Gans's cases, the ALJs issued these orders without any written motion, sua sponte, and without any notice to the agency. So I think there was a lot of confusion
But
here.
counsel, after those orders go out, when an OAH ALJ sends it, doesn't that go to the general counsel's office for the agency?
It does. And I think, again, the agency was really focused on getting these individuals their benefits as quickly as it could. And it wasn't focused on kind of these broader legal arguments about what these orders might mean for other cases. And I think you can see that in the exchange in the Hill case that we talked about in the reply brief, where counsel for Ms. Hill asked for one of these orders. The ALJ repeated back what she understood the request to be, which was to get Ms. Hill her benefits within a week and correct the problem. And the representative said, we have no objection to that. And we've never had any objection to an order requiring the payment of benefits that were due. So I just don't think that the parties were all on the same page about what was being asked for and what the orders would really mean until the contempt proceedings began and we began to understand that our friends on the other side read these orders much more broadly than we had thought. These hearings are designed to solve people's problems on the ground as quickly as possible. I think that you can see that in a number of different provisions, including the requirement that the ALJs issue their final decision within 60 days. I think if these were designed to be fact-finding hearings that discover things about DHS's broad policies, there wouldn't be a statutory requirement that you complete the proceedings in 60 days.
You know, given counsel, the issues of waiver or forfeiture and the difficulty that we always have in dealing with those issues, I'm wondering why we should spend much time on it when it's not clear that this case is a big deal. My question really is, why is this a big deal? Here's why I ask. The orders were issued in the various cases, and as far as I can tell, there's been no ongoing effort, certainly to try to enforce them. And if there were an effort in these or future cases, it seems to me that DHS would have its remedy in the Superior Court, where it could tell the Superior Court judge, look, there's been no discovery on these issues. There's been no hearing to establish that this, whatever this is a policy. We maintain that these orders are illegal. You shouldn't enforce them for that reason. And you could get out from under the orders that way, quite possibly. So I wonder why we ought to grapple with that, and we shouldn't just take a pass and say, right now, this is not a big deal. I do want to add to my background here that I realize the orders say something about DHS possibly going to judge in chambers if the order is not complied with. And maybe that envisions a proceeding where the plaintiffs could get some relief from judge in chambers without all of those procedural protections, discovery and the like. So maybe that's part of the answer, but I do wonder whether the ALJ had the authority to direct where in Superior Court the plaintiffs would go in any event. And And there certainly are other remedies. So if you could sort of factor that into your answer, I'd appreciate it. But basically, my question is, why is this a big deal? So why should we grapple with these waiver forfeiture issues?
So I think it is a big deal for a couple of reasons. One of which is that we think that the ALJs need some guidance from this court about what this provision of the Public Assistance Act means. What does it mean when it talks about a policy or legal interpretation? And does it extend to something like this where there were kind of disconnected computer errors or human errors affecting multiple people's benefits? I think that guidance is really needed, which is why we came directly here to get that guidance from this court. And I think you can also see that request from Judge McKenna when counsel did try to enforce one of these orders in the Superior Court, and she stayed the case pending guidance from this court about what the Public Assistance Act means. I agree with you that we would have some of those defenses in Superior Court if one of these orders was, they attempted to enforce them. But I think that really puts the agency at a disadvantage when it has to defend against a contempt proceeding where it's potentially liable for, as they requested, daily contempt sanctions until it fixes its computer system in a way that we don't really understand what that means. And so I think that if ALJs are going to be issuing orders like this, they need to have clarity about what the agency should be doing in response, what this policy is and how it should be corrected. And they should be basing it on actual evidence rather than kind of these informal discussions between counsel and often unrepresented claimants. And so we think that guidance needs to come from this court in the first instance, rather than wait for the Superior Court proceedings. But I agree with you, we would have defenses in that instance. But
Yeah,
I
I
think
mean, that's sort of usually the backward way of looking at it. You know, we're not a court of first review. We're usually a court of appellate review. And I think what Judge Thompson's pointing out is we don't have anybody who's chimed in on this issue yet because the issue wasn't raised before the ALJs. It's pending in Superior Court. And because this appeal is pending, the Superior Court hasn't weighed in on it yet. So we don't have anybody chiming in. And that's a bit of a weird situation for us as a court of effectively last resort to jump into it is a pretty thorny topic. So I get what you're saying that, you know, these orders do have pretty significant consequences in the sense that you could be held in contempt if you violate them. But everything you're saying about the illegality of the orders before us today is something you could interpose as a defense against contempt proceedings in the Superior Court, right?
that is true, but I think it is fundamentally a different question between are these orders valid, which is, I think, the question before this court, and what kind of procedures need to go into making one of these orders in the first place versus should the agency be held in contempt for violating one of the orders. And I think it would be appropriate for this court to give that guidance about what the law means rather than wait for the Superior Court to decide on potentially very fact-intensive grounds, whether this order has been violated and that should the agency be held in contempt? Did they have proper
I mean,
notice?
counsel, it seemed like the Superior Court had questions about the legality of the order itself.
She certainly did, yes.
And why should we just on a record, I mean, I'm gonna repeat the same question because we got basically the same answer, but why shouldn't it be hashed out somewhere before it comes to us?
Well, the ordinary way that orders are challenged is for a direct appeal to this court from OAH. And this court, I think, needs to provide that guidance. And I think this is probably the most expeditious way to do it, to decide this case now. So that the ALJ, I mean, these cases are ongoing. We have a lot of public benefits cases every day at OAH. And I think the ALJs need guidance urgently from this court rather
So
than.
you
wait
think
for-
we have a sufficient record to provide guidance on this?
I think there's a sufficient record to provide guidance on the legal questions about what does it mean to have a policy, construction, or interpretation, and what kind of orders should be issued. I think it would be perfectly reasonable for this court to remand for further fact finding after providing that guidance, as it did in Co. This court said, here's the answer to the legal question about whether you can issue this kind of order. We're remanding because you need further fact finding about whether this policy even exists. Has it already been corrected? And I think that would be an appropriate course here as well. But I do urge the court to address the legal questions presented here because I think we are at risk of going for a long period of time with ALJs issuing these orders that could potentially put the agency in a real bind in a contempt proceeding. I agree that all of those defenses would be available, but I don't think it's fair to make the agency wait until it's held in contempt to decide whether these orders are valid.
Do you think that the orders, one or more of them, is fairly read actually to require DHS to fix its computer system? I noticed that in the Butler order, perhaps not the written order, but from the bench, the court said something like, so I'll issue the order telling them to address the problems with the computer system. They probably can't do that within 7 calendar days, but, and the court goes on. So I was left thinking the court didn't really mean that. I mean, clearly the court meant fix this complainant's problem. But do you read the orders as actually requiring kind of an overhaul of the computer system or fixes to the system?
So it's difficult to answer that question because I think the orders are quite vague about what they're asking the agency to do. I think one way to read them is very narrowly and saying, fix the problem in this individual claimant's case. And I think that's how the representatives at the hearings understood what the ALJs were asking of them. But I think this litigation has really crystallized that our friends on the other side read the orders much more broadly as requiring a change to how the agency operates on a daily basis. And if that's how the orders are being read, then I do think we have a real problem because there's no guidance about what is wrong with the computer system that needs to be fixed. My friend's brief says that the agency should simply switch to a manual solution, but that's simply not possible for some of these programs. I mean, Medicaid has to be administered using a computer. No one's cutting a check to provide benefits. It's insurance. So you need an active Medicaid card. There's no way to do that without using a computer. SNAP benefits have to be loaded onto an EBT card. There's no way to do that manually without using a computer. So if that's what the agency is being asked to do, I don't know how the agency can comply with that order. And I think that's why we need some guidance from this court about what steps need to go into one of these orders and what the proper scope of them is. And I don't think it's a broad change your computer system, make your computer system better, because I think that's exactly what this court in Schumann said that ALJs aren't empowered to do and shouldn't be doing in these hearings. And I think that's especially true in public assistance cases where we're under a tight timeline. We're trying to solve complicated problems that could be due to a number of different issues. And the focus is on getting the person the benefits as quickly as we can. We don't always live up to that aspiration. I think that is perfectly clear from the record, but that is the focus of these hearings, and it's what should be the focus of these hearings. They shouldn't become these adversarial proceedings where lawyers are preserving objections and saying, well, that wasn't in your hearing request, so we can't address any of those other issues that you're bringing up now. It's more of a collaborative process to get the person the benefits, get them made whole as they should be, and just solve these problems as quickly as possible. So unless the court has any further questions,
I do have at least one. I'd like to know, you started to get to this and we cut you off and moved you to the forfeiture point. As I read the plain text of 4.210.16, it's talking about a departmental policy or the administrative construction or interpretation of relevant statutes, regulations, orders, or departmental directives. What about that limits it exclusively in the plain language to kind of the legal determination that you're talking about, as opposed to a practical determination with legal effects, which is what I understand legal aid to be focusing on?
So I think the language, departmental policy, construction, or interpretation really speaks to a legal misinterpretation by the agency. So if, for example, the agency had a regulation that misinterpreted the SNAP Act's timing requirements, for example, and an ALJ said, well, this resulted in someone's benefits getting misadministered, you need to fix that regulation. That is, I think, what this statute is speaking to. I don't think it's speaking to, general practices that may be used by the agency. I think those sorts of things, 1983 and Monell liability in Superior Court is the proper way to address those problems. But this, I think, is very narrowly tailored to legal misinterpretation by the agency that can be corrected. And it provides like a pretty clear path for that, which I think is fundamentally different than what a 1983 litigation would be about.
So I understand the position. The question really is like, why?
So I think if you look at the language, policy, construction, or interpretation, that's talking about a deliberate interpretation officially established by an agency of interpreting a statute or regulation. I think that really speaks to something that the agency has done intentionally and that it's applying across the board. And if you look at paragraph C, it again talks about if this policy has been applied to other people, you need to notify them. I don't think that, for example, in these cases where we had human errors resulting in a misadministration of benefits, that you could feasibly say that that's a policy that affects other people in a defined way. I don't know how you would notify those individuals of that application of that policy or misinterpretation. I think it's really about legal errors contained in a departmental policy where the agency has made a mistake of law, not a mistake of fact or human error in administration.
I spent some time thinking about whether what we're dealing with here is a legal misinterpretation. So I'd like to hear your answer to this question. So DC Code section 4-205.26 says that the agency is to pay benefits with reasonable promptness unless, and one of the unlesses is, unless an administrative or other emergency, or unless there is an administrative or other emergency that could not be reasonably controlled.
Mhm.
So I thought, well, maybe the misinterpretation here, the alleged misinterpretation, is that the situations involved in these claimants' cases with the inability to fix the problem until some computerized mechanism or something was fixed, is inappropriately regarded as a matter of policy, it is inappropriately regarded as an emergency that could not reasonably be controlled, or an administrative function that could not reasonably be controlled. It's beyond the control of the agency. It seems to me one could misinterpret that phrase, an emergency that could not be reasonably controlled. And you could say this qualifies as that, or this doesn't qualify as that. And the problem here is that DHS is saying that its computer situation qualifies as that when it doesn't. What's your response to that?
So I think that's an interesting argument. I don't think the agency has ever contended that that's how it was interpreting that statute. I think that, and it's not what the ALJ said the misinterpretation of law was. The reason they pointed to that specific statute in the DC Code was they said that you missed the timing requirements, which is 45 days for processing initial applications for TANF and Medicaid. That timing requirement wasn't violated with any respect to any of the people here. So that's what the ALJ said the misinterpretation of 0.26 was. I don't think there was any contention that the agency was misinterpreting that emergency exception. And so I guess my response to that is I don't think that that's been something that anyone has ever.
I'm making up an argument
Right.
your opponents didn't make.
Right. So I think that if that is what the law that's being misinterpreted is, I think we would need a remand to discuss whether that's something the agency has a policy about or interpretation about. And I frankly, standing here, don't know what the agency's interpretation of that would be with respect to computer issues. It always sounded to me like something more like something like the COVID pandemic, where we had a huge influx of SNAP and TANF applications that just made it impossible to process everyone as quickly as we would like to. That sounds more like an emergency, but I'm not sure whether they would interpret that to include an issue with a computer system. But again, I think if you look carefully at the timelines of what happened here, many of these beneficiaries were provided with their benefits in a timely fashion, despite some computer hiccups along the way. I think Harrison's case is a very good example of that, where 4 days after her SNAP and TANF benefits expired, the agency restored them. It also made underpayments a few days later to compensate for earlier payments that were too low. And then it made manual payments in the interim for the next few months while it fixed the computer issue related to child support that was still in her profile. So she never went a month during those 3 months where she wasn't fully compensated the way that she should have been, despite the computer errors. And so I think that that really shows that there is no policy of throwing up our hands when faced with a computer problem. The agency was attacking the issue both by making the manual payments and by trying to fix whatever computer IT issue was affecting her case. And it was doing both of those things at the same time, which, of according to legal aid's brief, is exactly what they should be doing. And so I think that just shows there's no policy here. Unless the court has further questions, I'll reserve any remaining time for rebuttal.
All right, thank you, counsel. We'll give you a few minutes on rebuttal. We'll now hear from counsel for the respondents.
Thank you, Your Honor. Good morning. I'm Jonathan Levy with Legal Aid DC, representing all 5 respondents here. The policy that we're talking about here that applied to all 5 respondents in this case is exactly the same as the policy that was at issue in Coe. And that is apparent from footnote 4 in Coe that both of the parties here rely upon, and also from some of the other language in the main text of Coe. And I would like to turn to that and focus on it for a moment. The policy that was found in Coe was not a policy of imperfection or a policy of having computers that occasionally or often make mistakes. The policy, the statement by this court in Coe was that the ALJ found a policy because DHS was aware of the problem, meaning the computer problem. And being aware of the computer problem, what DHS did was it followed the erroneous computer instead of doing what it knew to be legally required. That is exactly the same as the policy that was followed with respect to the 5 respondents at issue here. In each case, there was
But we didn't say in Co that any order would be okay. We remanded for further factual findings. We didn't say that this is perfectly fine. So I'm not sure how far Coe gets you.
Well, Coe gets us to the policy, right? Coe gets up to the question of policy. And I think, Judge Thompson, it also answers your question about misinterpretation of law. The statute does not refer to misinterpretation of law. It refers to a misapplication of law. And in Coe itself, there was absolutely no misinterpretation of law. The parties came before this court and all of them agreed as to what the relevant law required. The relevant law, which was federal law in that case, required that certain checks be performed before termination notices were sent to Medicaid beneficiaries. And all of the parties agreed that that was the law. So there was no misinterpretation of law. The problem was a misapplication of that law. The problem was that DHS did not do that.
I don't think I read Coe that way. When I look at footnote 4, what it's saying is, well, DHS says this was a technological error, not any kind of policy. But we have a factual finding to the contrary, that it was a policy. And on remand, we're not saying that that was appropriate or not. You know, we'll let them figure that out on remand. So I'm not sure if it gets you. I might agree if Coe says sort of shutting your eyes to persistent technological errors constitutes a policy, that'd be very helpful to your case here. I don't think Coe says that. I think Coe says, well, we have a finding that it was a policy. We're going to be agnostic about that, and we'll remand for them to figure out whether or not really any policy exists. Why isn't that the better reading of Coe?
I think that's not the better reading of Coe for 2 reasons. The first is that in Coe, there was this extant finding of a policy by the ALJ. And then DHS, by the time the case got to appeal, said that they had made various changes and that there was no longer this problem. And when this court remanded, it did not reverse the finding below, and it did not remand and say, you need to find ALJ, you need to find in the first instance whether there is a policy here. It said that on remand, the ALJ should consider whether DHS's unlawful policy still exists. So that looks very close to a finding that there was an unlawful policy to begin with. And perhaps more importantly for our purposes here, in this case, DHS says that there was and agrees that there was an unlawful policy as that word is defined in the statute in Coe, and that's on page 36 of its opening brief. So I think those 2 things go very far to suggesting that this court in Coe did in fact believe that there was an unlawful policy under the terms of this statute. And that policy, again, is essentially the same as the policy here. And it was found by the ALJ in Coe on much less evidence than there is here. And I want to turn to some of that evidence here because DHS told you that the evidence showed that it was working as quickly as possible to solve these problems. And that's not what any of the three ALJs here found. And there's significant evidence in the record to suggest that beyond the fact that DHS simply came to 6, 7 ALJ hearings and kept saying things like, we're working on it, it's a computer problem, we're doing another ticket, et cetera.
I'm having a little trouble following the argument that there was a policy at issue in Co. And so there's a policy in issue here. I may be misremembering the facts of Co. Is Co the case in which we described the policy of not looking for other grounds of Medicaid eligibility before taking someone off the rolls? I mean, you used to qualify under this section, but you could have qualified under that one, only we didn't look to see because we didn't want to duplicate. Well, we didn't want to make payments on your behalf if you were ineligible, and better to keep the things separate until you're thrown off one roll and added to the next. That's Co, correct?
Those are the
facts of Co.
Yes.
And so I'm having trouble seeing what that policy has to do with the alleged policy here. How is?
Yes, those facts constitute what was the misapplication of law in Co, but they do not constitute what was the policy in Co. And again, that's in footnote 4. What this court said in describing the policy was the ALJ found a policy. Let me start with the beginning. DHS argued before the ALJ that a technological barrier, not DHS policy, was responsible for the misapplication of law. The ALJ found a policy because DHS was aware of the problem, meaning the computer problem. But rather than declining to issue the Medicaid termination notice, it instead chose to issue a notice of termination in violation of federal law, unquote. So the description of the violation there is not the computer problem, that the computer was programmed inconsistently with the law. That's not what the policy was. The policy was that DHS, knowing that the computer, or aware, I guess is the word, aware that its own computer, it should be aware of that, aware that its own computer was capable or set to send out these wrong notices, sent them anyway, and didn't do something else. In other words, the policy was that the agency followed the dictates of its computer, even when it knew that those dictates were unlawful, instead of choosing to do what it knew was lawfully required.
And that sounds a lot like Schumann as well. And I don't think your brief ever addresses Schumann. So Schumann was also sort of a persistent computer problem where we said, no, you don't get to issue injunctions, ALJ. Superior Court might, but the ALJ doesn't get to issue injunctions telling the agency to sort of get their act together. That's the type of thing, a Superior Court might put an agency under supervision of some type, but ALJs don't generally have that authority. So what is your distinction of Schumann? Why isn't this just like it?
Well, Co itself distinguished, Schumann, and said that the idea that ALJs can issue orders under this provision 4.210.16 does not violate Schumann because there's a statute that authorizes them. I distinguish Schumann because in Schumann, the ALJ specifically ordered the agency to replace its entire computer system. And that is not at all what has happened here. And I want to go to the text of what the ALJs said. Now, it would be inappropriate for an ALJ and certainly for legal aid to tell DHS exactly how to fix its problems. That's not our role. And the ALJs here did not purport to do that, but they certainly didn't purport to order the agency to replace their computers or even fix their computers. On page JA 1387, one of the ALJs in the Butler case said, characterized its own previous order, their own previous order as directing the agency to correct its unlawful policy of withholding benefits to which beneficiaries are legally entitled based on internet computer errors, rather than issuing those benefits manually. And DHS just stood before you and said, it is impossible to issue benefits manually. And then 5 minutes after that, it said, we issued benefits manually to Ms. Harrison and in a number of these other cases.
I think they said that it's impossible to issue some benefits manually, EBT cards, SNAP benefits. What's the inconsistency with some of these things we need to do electronically, some can be done manually?
They did the very things that they were asked to do. They have done the very things that they are being asked to do manually in the past. They represented repeatedly to this court, in fact, and to the ALJs that it was capable of making manual payments. And part of the problem here is that there is direct evidence that they chose to seek IT solutions over manual payments. And there are two key points of these in the record. One is at JA 1111. And in this instance, DHS was asked after prolonged delays here, hey, can you just, do this manually and do this quickly and do it manually? And the response was, and this is a manual retroactive payment, the DHS refers to it as retro payments. And DHS said, as far as the retro payment, I believe they are trying to get the system to generate it so that the system can issue the appropriate notices in addition to the payments. But yeah.
Reasonable to rely on their primary system. And maybe you can clarify for me, there are various delays across the different cases. Some were a month or two, some were a matter of weeks. I think there was at least one that was longer, but how much delay are we talking about in this specific instance? And at what point, in your view, does it become unreasonable for them to try to make their system that's supposed to be doing the primary work?
I think that was a primary determination for the ALJs who were, in the trenches at each case, going from week to week, seeing that the delay was continuing. And in each of these cases, the delay was unacceptable, and it was often a matter of months. And I know that months doesn't necessarily sound like a long period of time in general, but it's important to remember that this is SNAP, this is Medicaid, this is TANF. So the purpose of SNAP is the predominant benefit here. And so, for example, for Ms. Hill, she was supposed to get SNAP benefits on February 4th. And the purpose of those benefits was to allow her to feed her family for the month of February. Those benefits were finally paid in mid-April. And the agency says she was made whole. They were finally paid in mid-April. It was only 3 months late, no harm, no foul. But it really is a very severe harm that we're talking about in these cases from even a few months delay. You obviously can't retroactively feed your children. And so that's an important point to make. There are also statutory deadlines and regulatory deadlines that are, in many cases, the law that was misapplied in this case. So, for example, several of these respondents were entitled to greater benefits because either their income went down or their family consistency changed. So Ms. Gans had a baby. And she did not get SNAP for that additional child for over a year. So when you're talking about, is there a de minimis amount of time? Maybe. The ALJs are in a perfect position to determine what that de minimis amount of time is. And DHS has not argued that what DHS has argued essentially is that as long as they say we're trying, and they issue the words computer, IT, technology, then there's an infinite amount of time that both the beneficiaries and the ALJs have to wait. And we think that's inappropriate.
Can I ask if you want to persist with the argument in your brief that they've forfeited these arguments before the ALJ? Because, they make a point that really it would be better for this court to chime in sooner rather than later. You've chosen to spend your time today, but something that sounds quite similar. This is something urgent. It would be better if we chimed in sooner rather than later. So even if I thought they had forfeited these arguments before the ALJ, you can always waive the waiver, as we say sometimes, and say, we actually would like a ruling from this court. So what's your position on whether or not we should take a forfeiture route or address the merits of these arguments?
You should not take the forfeiture out, and I'm not sure that even if we were to waive, it would actually help the court decide the issues, because this is not just a sort of gotcha argument that like you failed to raise these issues. The problem is that these issues, most of them are factual, and the DHS's failure to raise them before the ALJs does not just constitute a waiver or forfeiture, but it also means that there is no record to go on for this court.
I'm sorry, I took your first answer to be saying the opposite of what I understand the substance of your answer to
Sorry.
be. No, my question was probably imprecise. When I refer to the forfeiture route,
Yes.
my question is, should we say, as you argued in your brief, do you stand by this argument that they forfeited these complaints before the ALJs, so we shouldn't even get to the merits of it? And your first answer was we shouldn't take the forfeiture route, which I thought was that. But then it sounded to me like you were saying, yes, these were forfeited arguments because there's no evidentiary record, and that's a big problem. So you shouldn't address the merits. Which one was the answer?
Let me try to be as
Sure.
precise as I can. I think there are two related issues. One is a legal issue of forfeiture. It is the legal doctrine of this court that a party before OAH, even an unrepresented individual, forfeits the right to raise in front of this court any issues that they did not raise below. That's a sort of legal bar. And we raise that and we stand by that because the agency has a flock of lawyers at their disposal. The ALJs in this case begged and pleaded for lawyers to appear. They sent the notices to lawyers. And at the very end, in June of 2023, one of the ALJs actually ordered a DHS attorney to appear. And the result of that was an argument between the ALJ and the attorney as to whether the ALJ had the authority to order an attorney to appear. So there was a practice by DHS of not having attorneys here. But even an unrepresented party, as a legal matter, waives their rights if they don't raise them. And I want to cite an important case for that proposition, which is Goodman v. DC Rental Housing Commission 573 A 2nd 1293, which says both that an unrepresented person waives and that even if there's an issue that doesn't arise until after the agency issues its order, that issue is still waived if there is the ability to seek reconsideration and an unrepresented person fails to do that. So that's DHS really did forfeit, and it chose to forfeit. It wasn't by a mistake. So we stand by that. But the second part is that as a result of that forfeiture, the record here simply doesn't contain information or discussion that would facilitate this court, as Your Honor mentioned, a court of last resort, from deciding these issues. So, for example, on page 50 of its opening brief, DHS says, far narrower orders would have afforded these 5 beneficiaries complete relief. And they essentially say the OAH erred because the orders were too broad. But in the 1,600 pages of this record, and in all of the dozens of hearings that took place, both before and after the orders were issued, DHS never asked for narrower orders. And so it's asking you to do this in the first instance. And that is first of all, that's forfeiture as a matter of law. But second of all, it deprives this court of the benefit of seeing what the discussion would have looked like before an ALJ, what evidence or argument DHS could have made, what counter evidence and argument the respondents could have produced, and what the ALJ's thought processes were. And all of that DHS deprived this court of by simply not reacting, and not only not reacting, but in at least one case, affirmatively saying that there was no objection to the entry of these orders that it now has a large number of objections to.
And one more question. Do you agree that DHS in Superior Court proceedings can interpose a defense that these are illegal orders? In other words, is this issue coming back up to us regardless? Because in the contempt proceedings that are currently before, or that were before Judge McKenna, I don't know if they still are, this will all be litigated. Or do you think that that's no defense? Do you think that they wouldn't have any defense to a contempt that the underlying orders are illegal? I think they would, but I don't know what your take is on that.
It would be a question for Superior Court in the first instance as to whether they had forfeited any, some or all of their objections. In general, when there's an equitable enforcement action in Superior Court, there are defenses, but they are limited. So for example, the defense of impossibility, which is one of the defenses that the agency raises here, I don't think it holds much water, and I think this record refutes that defense. But that defense is certainly available to them in Superior Court. The defense that the underlying order is void is a defense that's available, and the defense of substantial compliance, which sort of relates to the defense of, we fix it quickly enough. Those are all available in Superior Court. So, whether it's inevitable that it come back here is a different question. The agency, our hope, of course, is that these orders having been duly issued by 3 different ALJs, that DHS would acquiesce and would start complying with them in the same way, and this goes to the argument of impossibility, in the same way that it complied. There was no order issued in CO, but it fixed the problem in CO such that there didn't ultimately need to be an order issued. And what DHS says about that, this is in footnote 2 on page 4 of its reply brief, is DHS was able to correct the specific issue by creating an interim workaround and modifying its systems programming. There is no reason to think, and no evidence was presented below and no argument was made below, that it couldn't solve the problem here in the same way that it solved the problem in CO. And there is also no reason to think, and the evidence below strongly suggests, that it could solve the problem here by issuing manual payments appropriately in the cases where this issue comes up. But what we know from CO is that what it has done up until this point is insufficient, because what it said to the court in CO was, what CO says is that DHS asserted it would address cases on an ad hoc basis as they are brought to the agency's attention. And that's what the agency did in CO, and that's what the agency did in all 5 of these cases here. It dealt with it. It said, we have no system for doing this. It's an ad hoc. We're trying the best we can. Our computer system is a technological barrier, which is the exact same term they used in CO. And this court didn't say, oh, you have an ad hoc system. You're trying the best you can. An order under 4-21016 is inappropriate here. Instead, this court remanded to see what had changed, and if nothing had changed, for the entry of an order.
And to get some more factual findings to undergird a very strong order, right? But along those lines, I'd like to hear a little more directly to the response to the argument from your opposing counsel. Well, this really wasn't an adversarial, these really aren't adversarial proceedings. These are problem-solving proceedings. We saw these orders, but even interpreting them, we would have viewed them much more narrowly. Like, is there some wiggle room there for them on that point, that they didn't see it coming, that this was a broad injunction equivalent, as opposed to individual orders like fix it in this case?
The example that they used for that is Hill. And I think that's a very good example. And I'd like to turn to that and look at that in some detail. On page 1477 of the joint appendix, this follows legal aid attorney talking about the broad remedial orders and asking the ALJ to issue such an order. And the ALJ said, do you have any objection to that Mr. Manga, who was the DHS representative. As essentially what Ms. McFeely, that's the legal aid attorney, is requesting is that I issue an order ordering DHS to cease this illegal policy where they are denying benefits based on the faulty computer program. That's a very clear statement of the order that that he ultimately entered. And he says, do you have any questions about that? That's to the DHS representative. And the DHS representative responds, no, Your Honor. Then, so I think the possibility of confusion there is very, very low. There are later discussions about the timing of the orders. And the ALJ says, I'm going to issue this order to fix the Ms. Hill's benefits, and I'm going to require DHS to comply within 7 days. And then what about the timing for the other separate order that I'm going to issue on the, under 4/2/10/16? What should we do about that? And there was some discussion, and the judge decided that that would also be issued with 7 days, and the DHS representative said nothing about that. So the idea that there was any, my point is it was clear that there were two separate orders, that one was going to require and did require the agency to actually disperse the benefits to Ms. Hill. That order was issued, it was violated, and that there was going to be a separate order to DHS requiring the agency to fix its unlawful policy.
And
So the idea that-
correct me if I'm wrong, sorry to cut you off, but at this point, by the time of this hearing, DHS already has at least one order, has had the order in Harrison for over a month, which would tell it exactly what this ALJ is contemplating, right?
That is correct.
And still is not sending, and despite having the same legal counsel in Hill, as Ms. Hill had the same legal counsel, your organization as the counsel in Harrison, DHS is still not sending lawyers to these hearings, despite seemingly having pretty good idea of exactly what's going on.
Well, it's actually worse than that, Your Honor. And I do think it's important to understand how DHS addresses these proceedings. In Harrison, the ALJ began in a sort of logically gentle way and to help clarify what was going on by issuing an entire proposed order that would give the parties the opportunity to comment on it, and would certainly and did certainly give DHS the opportunity to interpose any of the objections that it now has before this court. It's impossible to comply with that. We're doing the best we can. We just can't do it. There's no statute that we're violating. Any of the objections that it now raises, it had the opportunity to raise that when the ALJ in the Harrison case said, here's a proposed order. Parties, what do you think of this? And I'm going to hold a hearing to discuss this. And so at the hearing, one would have expected DHS to show up with counsel and to make all of its objections. It didn't show up at all. It not only didn't bring a lawyer, it didn't bring a representative. It simply didn't show up. And then the ALJ considered some of the comments that were made by Ms. Harrison's counsel at that hearing, and it issued an actual order, not a proposed order. And it held and it scheduled a hearing very soon after that so that the parties could talk about whether the order had been complied with or whether there were any issues, et cetera. And at that hearing, again, DHS did not send a lawyer. They didn't send anyone. They just didn't show up. And so you can understand why the ALJ, reacted the way the ALJs here in general reacted the way they did. But also, despite that, they were very careful. But the idea that DHS didn't understand what was going on by the time the fifth order was issued in this case, months after the first order was issued, or that it didn't have the opportunity to present its arguments, it's wrong. And the idea that these are indeed not judicial proceedings, and they are to some extent, and in many cases, they are problem solving. But that doesn't mean that when DHS sends a representative to one of these hearings, that it has no responsibility for what that representative says or does and can completely disclaim it later, nor does it mean that the agency which the ALJs copied, the ALJs copied the Office of General Counsel of this agency, and that the agency is free to simply say, oh, we'll disregard these orders, we'll keep sending representatives instead of lawyers. And then if there's any problem, we'll just go to the Court of Appeals and say, oh, you know, we didn't raise anything below because we didn't really know, or we didn't really have the opportunity. That is not an appropriate way, that frankly, that's not an appropriate use of this court as a court of last jurisdiction.
All right.
That,
Counselor, I think we've heard your arguments, unless my colleagues have any further
I
questions.
was just going to follow up
Sure.
on the question earlier about what defenses would be available if you were to try to enforce these orders in the Superior Court. And I take it your answer would be some of the defenses that your opponent has in mind aren't available, wouldn't be available because they were waived, forfeited. Is that your response?
I think it is likely that some would be waived or forfeited, but I
The
actually-
argument that this order was overly broad.
Well,
Is that one available?
it is in a certain sense because it's an equitable proceeding. And so when you're in front of a judge sitting in equity, part of what the judge is called upon to do, the judge has a broad equitable authority. And so one of the things that the judge can do is issue their own order that clarifies the ALJ's order. So for example, the complaint that the orders here are vague is something that could be fixed by a judge sitting in Superior Court. The argument that that it's impossible is not waived because both because that's a defense and because it allows the Superior Court judge to exercise equitable discretion in terms of what the remedy is. In other words, DHS comes before this court and says, we're really worried about getting daily fines. But the Superior Court would be able to consider their defenses in determining whether to issue any daily fine at all or the amount of a daily fine. They would be able to consider how difficult it is to comply with these orders, whether they are difficult to comply with because they're vague, whether they're impossible to comply with, or whether they're being substantially complied with. All of those things would be and are currently in front of the Superior Court. If there are no further questions, thank you, Your Honor.
Thank you, Counselor. Mr. Girton, we'll give you a few minutes for rebuttal.
Thank you, Your Honors. I'd like to start, I think, with Judge Deal, some of your questions about how to read Co. And I think I agree that the issue of whether there was a policy in Co was not actually presented to the court. The only issue is whether the ALJ had the power to issue an order under this provision of the Public Assistance Act. And so I don't think there was any contest about the policy. And I think that footnote 4 is phrased very carefully to say the ALJ found there to be a policy, doesn't endorse that reasoning, but it was never really contested before the Court of Appeals. So I think that it was
I
just.
didn't find it so carefully worded. At one point, they did refer to the unlawful policy, right?
So that's what the ALJ found, and that wasn't contested on appeal. So the only question was the legal one of whether they could issue an order to correct it.
It does make it seem like it's a factual question, though, and not a legal one, whereas I would tend to think of that as at least a quasi-legal question of, you know, there are policies and then there are just habitual mistakes. And the court seemed to say, well, we just defer to the ALJ on whether or not this is a policy. Which, I mean, I'm not sure if that's the right way of thinking about it, but I take your point that we weren't exactly focused in on the question.
Right. So I agree with you. It's both a factual and legal question. I just don't think it was presented in the case. The agency didn't contest that factual finding. But even if you assume that something like Co is a policy, I think that the factual circumstances Judge Thompson was walking through really show how that's different than this case. In Co, you had an identifiable group of beneficiaries in a particular situation whose Medicaid eligibility was expiring due to a temporary disability, and they were all going to be affected in the same way because of this computer issue. Here, we have 5 different beneficiaries in different benefits programs. They all experienced different computer issues. Some of them wasn't even related to a computer. So I just don't think we can infer that the same kind of policy is at work. I also wanted to give a little more clarity to Judge Howard, your question about how do we know that this statute is supposed to address legal issues? And I think that the key language in subsection B is that there must be a misapplication of law contained in the policy. So the policy itself has to have the misapplication of law, not just that the agency misapplied the law in a particular case, but that the policy itself contains that misapplication that the ALJ can order the agency to correct. So I think that answers that part of the question. And then the other point I wanted to make was that I still haven't heard anything from my friend on the other side about how the agency is supposed to comply with these orders. He says that all you need to do is use manual payments. But in Harrison's case, we did issue manual payments while we were working to correct the computer. So I don't understand why the ALJ would have issued an order at all. If all that they wanted was manual payments, those were already being issued. They've been issued for 2 months before the first order came out. So if that's not already complying with the order, then something else must be at work. And the language that the ALJ has used was stop relying on this faulty computer system. I think that does speak to something more like Schumann, where the agency was ordered to fix or overhaul its entire computer system or stop using it. And I think that's something way beyond what I think the Public Assistance Act envisions ALJs doing in particular cases. And then I did want to speak to the waiver and forfeiture issue. We discussed this a bit in our reply brief, but my friend in discussing the Hill case, the exchange with ALJ Cruz left out a few key sentences that I think explain how this really was a problem-solving focused hearing. What happened after ALJ Cruz said, what Ms. McFeely is requesting is that issue an order ordering DHS to cease this illegal policy where they're denying benefits based on the faulty computer program. We'll order DHS to restore the benefits, issue the underpayments to Ms. Hill, and then schedule a hearing, maybe within a week or two, where DHS would have to come in and show that the situation has been rectified. Do you have any questions about that? I think that really speaks to a narrow problem solving as to Ms. Hill. Fix her problem within a week, not overhaul your whole computer system or change your policy. It's fix the issue as to her case. That's what I'm going to order you to do. And there's never been any objection to that. So I think that really illustrates how the parties were on different pages about what was happening here and what needed to occur to comply with the order. I fully acknowledge that more could have been done to make a record here, but I just don't think that these representatives were focused on those sort of legal preservation issues. They were focused on solving the benefits for a particular person.
So one thing I pointed out was that, DHS had an example of what this policy, what this order was going to look like that was issued in Harrison more than a month earlier. And they don't do anything about that order. They don't ask for reconsideration. So by the time you get to Hill, it's hard to understand the ALJ saying anything other than, I'm going to issue an order just like that one. Do you have any objection? And the answer is no, no objection. So I don't know how much it gets you to say, there's some imprecision in the language when all of this has been in the pipeline for, at least since mid-February when they moved for it, and late February when you had a proposed order, and early March when you had an entered order. I just don't know how DHS is still sitting on its hands come early April because of some, maybe the judge could have spoke more clearly, but it's this, you guys should know it's the same order coming down the pipeline.
So I think that this exchange and the lack of clarity shows that there was no intent to waive the argument that some sort of broad policy was at work here. And I think that kind of resolves the waiver question. As to forfeiture, I think I agree that there could have been more done to preserve some of these arguments, but the issues before the court are legal ones about the scope of the ALJ's authority. And I think this court can answer those questions even without further factual development. If further factual development is needed, I think then the right course of action is to do what happened in Coe.
Yeah, forfeiture isn't really about factual development, though. It's about, fairness to the parties, to the lower court, or in this case, ALJ, about did they actually get any notice of what you were going to come up and complain to us about, to give them a chance to correct it. Maybe the ALJ wouldn't have done this. So I don't know if, we could address a legal question. Yeah, maybe we don't need more factual finding. But generally speaking, forfeiture is pretty strong medicine. We very rarely, I think the two cases you cited for it being a discretionary doctrine, one kind of speaks of a manifest injustice. The other one is, well, bar counsel cases are a little bit different. Because we haven't imposed any sentencing yet. I don't really know why they're different, but we seem to say they're something of a different animal. There's not much. It's quite unusual for us to say, hey, you didn't raise this argument below, but we kind of feel like it's a good idea for us to address it now. It's an unusual course, at least. Do you want to point me to anything else as sort of a best case for you that supports the view that we can kind of just willy-nilly do that?
So I don't think the court can do it willy-nilly. I do agree that it's normally a strong presumption that the issue shouldn't be addressed. But I think here we have a unique constellation of issues where an agency is being represented by non-attorneys in a hearing that's designed to solve problems for vulnerable residents under tight timelines. We have a lot of vague questions about what really is being asked of the ALJs, what kind of orders are going to be issued, what do they really mean? I mean, I think today, what I heard from Mr. Levy was that exactly what happened in Harrison would have complied with the orders, but yet the order was still issued and they still think we're not complying with it. So I think there's still a little bit of confusion about what compliance really looks like. So I think all of those factors together are good reason to address the legal issues here and provide guidance. And I think that that's an unusual circumstance that merits the court going past the ordinary rules of forfeiture. But I certainly want to push back on the concept that there was intentional waiver here, because I just don't think that that was the case. And in several of these instances, the orders were issued sua sponte without notice from the ALJs. Nobody asked for one. And the individual was unrepresented. In Ebron's case, for example, the agency couldn't have sent a lawyer under the statute in that case, and the ALJ just issued the order sua sponte, addressing statutes that don't apply to Ebron's case, that weren't violated in Ebron's case, and that he wasn't being withheld any benefits at that point. So there was really no issue for an
And
order.
I'm sorry to ask one more question, but the respondents say in their brief, more or less, if one of these orders is okay, be it on a forfeiture ground or on the merits, they all basically say the same thing. You're going to have the same enforcement proceedings going in Superior Court. It's a broad injunction. So if one of them's okay, you don't need to address all of them. Because I can appreciate why the forfeiture interests are different case by case. Do you agree with that?
I don't completely agree with that because I think that the ALJs need to ground their orders in the facts and the law applicable to the case in front of them. And here we have a particularly unusual situation where these beneficiaries had different programs governed by different statutes, and yet the ALJs copy pasted some of the orders earlier. For example, talking about the deadline for paying Medicaid benefits, but they pasted it into an order about someone who's had an issue with SNAP. And so I think that just shows that they're drawing these connections that aren't warranted by either the law or the facts. And so it sort of is a problem for all of the orders. And I think that it's also somewhat in tension with their argument that we would have all of these defenses. If all of the orders are the same and they're addressing the same policy, that wouldn't really be true if there's these kind of fact-specific defenses.
Unless my colleagues have anything further. Thank you. Thank you,
you.
counselors. We appreciate the well-done briefs and arguments, and the case will be submitted. We will next hear argument in 23 FM 526, Wendy O. Block versus Charles X. Block. Counselor, whenever you're ready.
All right, Your Honor, I'll be reserving 3 minutes. On behalf of, may it please the court, Jeff Lones, on behalf of Wendy Block. This is an appeal involving a unique procedural issue. Judge Becker issued an order in which she found that an action should be tried in California. An issue then arose on a motion to alter amend by Mr. Block that I can't go back to California without an order. In other words, you just can't dismiss the action and send it back to California. I need an order that I can register under the Sister Judgment Act. We oppose that, saying that motion to alter amend by saying, look, California, he can go out and sue on the judgment. He doesn't have to have a money judgment. He's not a predicate for him to have an available forum. She holds that motion to alter or amend for a fairly extended period of time, and there's lots of briefing going on after that, because Mrs. Block says, if you're sending us back to California under his order, please make sure the following things occur. One, that you put in the order and judge portion of your order that all of her claims and defenses are preserved and are to be adjudicated in California, not just in the fact finding, but in the order. And we also ask that the order not be redacted in any way, because under a previous action, Mr. Block had redacted portions of Judge Kravitz's original judgment of absolute divorce. And we wanted to be sure that the California court had the full order in front of it. Mr. Block files after the court. I actually have to back up. Judge Kravitz first advised parties, Judge Beck first advised parties that she was inclined to send the matter back to California. And if anybody had any objection, to let them know. Mr. Block objected to that, saying, I need an order. We responded to that. She then ultimately enters an order in which she tries to, quote, solve the problem by simply entering a judgment, a money judgment that he could register, staying execution, and saying that the California court would have to adjudicate the defenses. And that then sets up a bunch of alter amend motions that go back and forth, because then Mr. Block wants to have prejudgment interest entered, which is fact intensive. At the end of it, Ms. Block says, if Mr. Block's California counsel is correct, and California cannot alter the judgment after it hears the claims and defenses, in other words, the judgment will always be the judgment, then this is not proper. And what the court should do is simply, if you are concerned about California exercising jurisdiction, stay the proceedings here. Let them go out there. And once California accepts jurisdiction, you can dismiss the action. And it's a lot like what the court suggested in the Mills versus Edna case. It's cited in Mr. Block's brief, right? Like a conditional dismissal. She responds to that by saying, no, the fix is I've delegated to, or I guess delegate is not the right word. I've said to California, you could adjudicate the defenses. If you decide that she's got defenses, he will be barred from enforcing the judgment. And that's where the rub comes in, right? The judgment will always be there. They may not lift the stay, but there will always be a judgment of record. And then Ms. Block would be forced to come back to the Superior Court of the District of Columbia, presumably to say, based on the determination that the stay wasn't fully lifted because her defenses were valid, please modify the underlying judgment. And so forth, back and forth we go.
Counsel, we get all these complexities, but cut to the part, what should have happened here? Like, what would a satisfactory order look like from your perspective?
Sure. I think the satisfactory order is, as we said in the last document, right? That the court could have found that it was not a convenient forum, stayed the action, stayed dismissal until California accepted jurisdiction and there was a proceeding out there. And they detail that in Aetna, like in the Aetna case, right? The Mills versus Aetna case, they were concerned about the statute of limitations in Virginia. They were concerned whether Aetna was not going to raise their statute of limitations and that the Virginia court would agree. So that this court sent it back and said that would be appropriate as long as, in that case, Ms. Mills had a forum. Well, that's the same thing here. Ms. Block has to have a forum to have her defenses heard. And so that's what it should have looked like. And the statute says stay or dismiss. And what Judge Becker did was a hybrid, right?
But it says stay or dismiss in whole or in part.
I agree.
So maybe you could stay in part, right? What's wrong with that?
Well, because I've never seen where you can bifurcate the claim from the defenses, right? It's actually quoted in Mr. Block's brief where Judge Becker says, look, before you can get a money judgment, the court has to hear this because there are always defenses to whether the money is owed, right? Like that's why there has to be a hearing on the request for a judgment. And what she did was, even though she recognized that, like there has to be an evidentiary hearing, she said there'd be an evidentiary hearing, she's given him a judgment and stated before there's really been a determination of whether or not Ms. Block owes it.
I mean, why is that so weird? Every money judgment, if somebody tries to register it, is subject to defenses being interposed against it. You go, I paid that judgment. So quash it. Don't let them put a lien on my property, or they waive the debt. In the interim, now granted, that's usually in the interim between when it was entered and when the next proceeding happened, which this case a little bit different. And your client still has all those defenses, so they can interpose in California. They can say it was waived, and the order makes that quite clear. They can raise all these defenses in California. So I can agree with you that it's an odd posture. An odd posture, largely because it's there were some defenses. I think this started in California, and there was some suggestion that they didn't have a judgment. And why shouldn't this just be viewed as the trial court in DC as reducing what is effectively a money judgment, though technically not, from 2011, where it says at this date certain you owe him that money, but because it's contingent, I think that's not actually a money judgment. Just reducing that prior order to a money judgment and saying, and whatever defenses they had along the way, they haven't waived. But why is that? I can appreciate some technical reasons why you're here and don't like what happened. But isn't everybody in the same place they would have been if the court in 2011 had just, when the date that triggered owing the money passed, which was sometime in 2011, I think. 12, they just said, okay, now it's a money judgment. Which is one way to interpret the order itself, but.
Yeah, I mean, the domestic relations statute in DC doesn't actually permit that. For instance, in the neighboring jurisdictions, Maryland and Virginia, they could do just that. They order to pay the money, and if it's not paid within the period of time, you can get a reduced judgment, right? But I want to answer so sure, in 2011, no one's saying that Mr. Block couldn't come back, it's 2012, when the money was paid and get relief. He certainly could have done that and gotten it reduced to judgment, right? Taken the action to reduce judgment, right? But then what happens here is everybody migrates to California. That's really the issue. And so no one is saying that he doesn't have a right to attempt to reduce judgment, because as Judge Becker recognized, the order in 2011, and whether the money was owed in 2022, lots has transpired. And the court has to hear that, including just, I've paid money towards it as an example, right? It's like her point was you don't just get it. He has to prove, he has to make the request, and she's entitled to an evidentiary hearing. To say why it's not like other cases that get registered, right? Because one of the challenges to registering a foreign judgment is court didn't have jurisdiction over me. I didn't get to present my evidence at the hearing. You need to vacate that judgment because I was not aware of it. Yeah, but the predicate for the foreign judgment being recognized under the Full Faith and Credit Act is that the person where the judgment was entered had all the benefits of due process. And really, that's what I'm coming back to. It's like, while the court recognized that there was a procedural that she had to follow to be able to give Mr. Block a judgment, if he was entitled to one, she didn't do that because she wanted to, as she said, I didn't want to parse what was going on in California. So I've come up with this solution. And to answer your question, if it wasn't as what Mr. Block's lawyers now say, which is that the California court cannot modify the judgment. That's what they say. Judgment is the judgment. That's where she can't get complete relief, right? Because she has been sent back there only to assert her claims and defenses. And that, as Judge Becker says, may mean that he's stayed from ever executing on it, but the judgment will still be a judgment of record. Because
Did the addition of interest take that beyond just codifying into a money judgment, what was in the divorce decree?
right, well, because the interest is a separate factual finding exercise, right? Mr. Block sought discretionary judgment from the date the payment would have been due in 2012. And there were lots of defenses as to why that didn't happen, including the fact by his own admission, he didn't do anything to 2019. Mrs. Block and the children were living in the house. He was, if nothing else, he was dilatory in attempting to enforce it. So should he get prejudgment interest? That second part of it was clearly required fact finding, but that judgment is out there now in California. The interest. So I don't know that that's the whole argument. I don't think the form affords her complete relief.
I didn't understand something you said at the beginning of your presentation. You said Mr. Block didn't need a judgment because he could sue on the judgment in California.
Money judgment.
Well, what you said was he didn't need a judgment because he could sue on the judgment. I was trying to figure out how he could sue on a judgment if he didn't have a judgment.
I apologize. Money judgment, which as Judge Becker pointed out, is a very specific type of judgment. What he had was he had an order from the Superior Court, Judge Kravitz, that she was to pay money. It's not a money judgment. He could always have gone out to California and said, she didn't comply with the order. She's here. Give full faith and credit to the divorce action order. She's never contested that he could have done that. Registration, as discussed in the Renoir case, is a different, it's an alternative to suing on a judgment, right? It's the ability to register a judgment. It's to expedite the process, but he didn't need a money judgment and he didn't have a money judgment. I'm running
Are
a
you
little back.
saying he didn't need a money judgment to register?
He needed a money judgment to register, but he didn't need a money judgment to ask California to give full faith and credit to the divorce judgment. That he could have always brought out there and asked them to give full faith and credit. They could have had a trial or a hearing or however they proceed in
The
California.
money judgment would just let him bypass a lot of court proceedings.
Correct.
Right.
Correct. It's an alternative, and it's 50 years now, but it's obviously something that the Uniform Act developed to expedite that proceeding.
Well, California didn't sign on. It's one of the two jurisdictions, right, that didn't sign on to the UEFJA or RUEFJA. I'm gonna put it together. So you
Uniform
have
Enforcement
that-
of Judgments Act.
Yes,
like that.
the Enforcement of Foreign
Foreign
Judgments Act, or the revised version. And so they've got their own sister state judgment act that makes it only the money judgment. And then you've got that enforcement action. But in this case, either which way, we would have been having court proceedings because there was a contestation about what was actually owed, right? Is there really a difference under either route practically from your understanding? I took a little look at the California laws.
I don't think so. It's what he was trying to do. Like he literally, when he originally went out there, he said to the California court, this is a money judgment. And it wasn't a money judgment. He voluntarily dismissed that. He could have argued that, I guess, with the California court. Okay, it's not that he got a ruling against him. He voluntarily dismissed it and came back here in an effort to get a money judgment. And he chose this forum to do that. And nobody is taking issue with the fact that California would be a more convenient forum for that. I got 30 seconds left, so.
We'll make sure to give you a few minutes for rebuttal
All
regardless.
right, any other questions? Did I answer your question?
I have a question about the wording of the court's order. I'm confused about what exactly it does. So it says that the California court may lift the stay, or let me try to follow the language. The stay may be lifted by a California court upon a finding that the judgment should be enforced in whole or in part against Ms. Block. I guess I have two questions. One is there authority for a court here to sort of delegate its ability to lift a judgment to a court elsewhere? California court may lift it. And number two, the order doesn't say what should happen or will happen if the California court finds that the judgment should not be enforced at all against Ms. Block. It just talked about should be enforced in whole or in part against Ms. Block. So what happens then,
All right, so.
to your understanding?
Well, so as to your first question, and we look for authority of the ability of a DC court to tell a foreign court to lift its stay. Right? Like, I couldn't find any authority. Let's just say it's unique, but there doesn't appear to be any reported cases. If it's been done, it hasn't been challenged at the appellate level. The second question is exactly what I'm saying the concern is. And I think Judge Becker says this particularly with regard to the interest when I point out that if the judgment can't be modified, if Mr. Block's counsel is correct, and after an evidentiary hearing, California cannot modify the judgment, right? Then this is not the right order. You can't do this. And she responds to the part that you just read, or in whole or in part. In other words, she's saying it can't be enforced. Okay, but that doesn't help her because the judgment's still of record. The stay may be in place. There may even be a finding by a California court. He's not entitled to have a stay lifted because we find she doesn't owe the money, but they can't modify the judgment. Now, I did cite, I think that Ms. Block could then come back. This is where it gets convoluted. I think she could come back to the Superior Court if that happens and ask the Superior Court to modify its judgment, and then I guess taking the fact that that judgment has now been reduced or modified or ever changed here back to California. But it becomes very convoluted. And I don't think if the predicate for forum nonconvenience is that you've got an alternate forum that can give you relief. And I don't see how that happens. Again, it's Mr. Block's counsel that raises this, that California cannot alter the judgment after it hears the defense.
Well, counsel, let me ask you a hypothetical. If the judge would have gone along, and I very much get what you're saying, the judge seemed to be trying to do some problem solving here. Not unreasonably with concerns the judge had about the challenge to the judgment in California. Or not judgment, but the attempt to register the judgment. This really has the feel of like a preliminary injunction, right? Like where the judge is trying to preserve the availability of this judgment as the judge understands from the case in front of her. If the judge had done something like ordered some kind of bond to compensate your client if they had to come back and get that removed here, would this be a perfectly fine procedural mechanism? Would you have had any objection there? Would that be acceptable?
So, I mean, in all candor, when I first got Judge Becker's order, and I think you'll see this in one of my things, I kind of admired her, as you say, pragmatism. She wanted to try to find a way to get a case out of DC, which two jurists had already found didn't belong here. Judge Leibowitz expressed that on two separate occasions. She raised a question of forum nonconvenience sua sponte. That was not raised by the parties. And so while I admire her creativity, I still think she has to act within the statute, right? And so at the appendix 619 is where I tell the judge what to do, because I understand, I don't agree with it. I want to be clear. I don't think there was procedural maneuvering. But if that's her concern, right? And I think it all emanates from, frankly, a lack of Mr. Block's California counsel keeps conflating registering a money judgment with its ability to just sue on the judgment, which is, you see, the statute says she could have done that in 2019, right? But I understood her concern. I definitely understood Judge Becker's concern. She was very forthright with me at the March 4th hearing about what her concern was. She wanted a matter off her docket, and she wanted to make sure that Mr. Block had his forum and this could be adjudicated on the merits, like no more binging back and forth between California and the District of Columbia. What I suggested is the answer was pretty straightforward. She stayed the DC proceeding until such time as California took jurisdiction, and then she could dismiss based on forum nonconvenience, because as she found, Mr. Block did not ever seriously challenge that California was the more appropriate forum. So if her concern was that Mr. Block, as the moving party, have a forum, once again, like the Mills case, she could have done that. Are there other ways to get there? Creatively, sure, I suppose. What she can't do, though, is put us, Ms. Block, in a situation where she's not getting full relief. She recognized there were defenses. They were entitled to a hearing, and as Justice observed, it could be determined she doesn't owe any money on the underlying judgment, but it's only the state that's being adjusted. So I think my solution is the one that she should have used, given her concern that there be no objection to California subject matter jurisdiction.
Our case law seems to recognize a conditional judgment. Could she have done that? Could she have entered a judgment on the condition that California will not exercise jurisdiction? Only if California does, the judgment goes away or has no effect?
Did you say that in her opinion? I don't recall her saying that. I've never heard of a conditional judgment,
I
right?
think there's a case whose name is Guevara or something like that. I can't remember the name precisely, but it talks about conditional judgment.
I think she could have done something like, as long as Ms. Block's rights were preserved, right? Like the objective here is to have the matter heard on the merits. Like there's no dispute about that, right? I mean, I'm sure I've been here since 2011, so I'd like to see this case reach its terminus. So she could have done that. Again, I think the appeal arises out of how she chose to do it. I think the tried and true method is, as I suggested, I get her reticence about just, her first instinct was just to dismiss it based on form nonconvenience and not put any conditions on it. And then she attempted to address Mr. Block's concern. Did I answer your question?
I think you did.
Okay.
Thank you.
At this point, I'm not sure. Any other questions?
My last one is, I noticed you introduced your client by a different name than what's captioned. It's as Wendy O. Block, and you introduced her, I assume, with a different last name. So, if you, oh, is it still Block?
It's still
I thought I
Block.
heard something different.
I may have mumbled.
Okay, I just wanted to make sure you didn't
Right.
need an
It's-
amended caption, and I was going to invite you to move for that if that was the
No,
case.
no, she's
Okay.
still Ms. Block and she is not remarried. So.
Okay, we will next hear from counsel for Mr. Block.
Please, Your Honor, Robert Costeca on behalf of the appellee, Charles Block. One of the issues that just arose is we had filed, this is a simple case, we had filed a motion for contempt or to enter a judgment. No defenses were raised to that other than the fact that we could not get contempt for the remedy of incarceration. The pleadings in this case, the appellant never raised any of these factual arguments he has that they may have a defense to this. They're not in their pleadings. Now, there was a prior proceeding from a year before where they did mention that they might have been a subsequent oral contract between the parties where he would enforce the judgment against her if one of the parties moved. But these are new pleadings. The previous case was dismissed without prejudice. This is a new complaint was filed for a motion for contempt, for a money judgment, and for a money judgment and for other relief. The court granted the motion for a money judgment, said the issue of contempt was moot. And in fact, the appellant, in its brief that was filed in the lower court, conceded the court has the inherent power to enter a money judgment in this case, and the court retained jurisdiction for the purpose of administering complete and particular enforcement of its own decrees. And I cited the case and say, you know, the reason this is in DC is this is a judgment of absolute divorce entered by the District of Columbia, and it is enforcing its own orders, and the court has a paramount interest in enforcing its own orders.
Can I just ask as a factual matter? So I think it makes perfect sense to me why the court, as a matter of its inherent jurisdiction, could have reduced the 2011 order to a money judgment in 2012 when the date to pay was owed, right? We said, once the state passed, they owed this money, and now the parties are before me, they agree the money hasn't been paid. You have a money judgment as of 2012. My concern about what the trial judge has done here is the trial judge has entered a money judgment as of 2023, which would seem to extinguish any defenses that Ms. Block might have about what happened in the 11 years in between 2012 and 2023. I take it your answer is, well, the judge was very careful to kind of preserve those defenses and punt them over to California.
Exactly. The court specifically reserves those in its order.
So is it a money judgment? So what is it? It's not really a money judgment.
It's a money judgment that can be enrolled in California, subject to defenses she has. I'm not sure what the defenses
yeah,
are, but it
Are
sounds like
you
we're.
really defending the order
it's
on
not-
appeal here? Because you're saying they didn't raise any defenses. Why is that in? So, I mean, are you wanting us to uphold this order or?
In my view, this is just, no defenses were raised in this portion of the litigation as to the entry of factual defenses, as to the entry of the order. Only the legal defense that the remedy of contempt could not be used because you cannot incarcerate contempt for an order to pay money.
So are you supporting the order or?
I am supporting the order because we have not we did not file a counter appeal. So we're
So what's the relevance of that point about the defenses at the
Well,
point that the order
know-
found form non-convenience?
Well, that's what the issue of the form of nonconvenience really doesn't matter because there's nothing that's currently raised for the court to decide whether it's a form of nonconvenience, except for the entry of a judgment based upon an order, a judgment of absolute divorce entered in the court. That was the only issue before this court. And after the judge worked her way through it, she found that it was appropriate for her to enter a money judgment based upon an order to pay money in the judgment of absolute divorce. It was an order to pay money since it was an order to pay money currently. which
Did
would
she
be the
really work
judgment.
her way through it that way? It seemed to me that the judge specifically didn't want to consider the California procedure and decided to enter this judgment to make sure that in California, there'd be a chance for a merits hearing.
And she preserved any rights that they would have in California. One of the issues was that there was evidence that was presented that in the briefs that when the judgment of absolute, because it is a judgment of absolute, was enrolled in California, they took the defensive position that it could not be enrolled in California.
Under the sister state money judgment.
Yes, which is
And
what.
I get that, but the judge didn't seem to consider the other procedural alternative and specifically declined to. Now, there is an argument from your opposing counsel about the factual finding that those defenses would be available. But what about the idea of to even go and enter this judgment on that basis of I want to ensure something is available in California? It was an error not to make a factual finding that there was otherwise no available remedy in California to pursue the judgment. I guess that may be, I may be jumbling it here. for you.
Because it wasn't a money judgment. So there's no available remedy to pursue. No money judgment existed until she entered her order.
Exactly, but registration was not the only option. Mr. Block could have easily sued for enforcement of the judgment in California. And I'm not sure how procedurally that would have been significantly different since there were these defenses, as Judge Deal referenced, across the 12-year time span in between that would have to be hashed out. So either which way, this was coming to some sort of evidentiary hearing in front of a judge at a minimum.
Well, I don't know what the ability to have enrolled a non-money judgment in California is, and then asking the California court to take a DC order and then to enroll a judgment to enforce a DC order. It seems that would be more of the providence of the DC court to do that. The DC court issued the order to pay money, and the DC court, and I've cited the cases, says that paramount interest, enforcing its own orders. And entering a money judgment was really the role of the Superior Court, and not for California to determine whether or not to enroll the order. Now, if there's other, and I don't know specifically what the defenses would be, but if the defenses are, subsequent contracts or oral contracts, those are separate actually causes of actions, not really defenses. But they weren't pled in this case. So it's hard for the Superior Court of DC to weigh the factors that go into the unpled defenses that may be asserted in California and make some analysis as to how those unpled defenses may be addressed in California.
Can you just remind me of something that I read in the briefs? There's a reference to a California lawyer who opined on something about whether California would do something, but now I forget what it is. Do you know what I'm talking
Yes,
about?
California law lawyer for the appellee, Mr. Block, opined that in the manner in which the judgment of absolute divorce was, it could not be enrolled in California. And he issued an affidavit, and that was attached to our hearing brief that was filed in the Superior Court.
Could not be
That-
enrolled,
actually
but
quoted.
not that it couldn't be enforced, right?
What?
It could not be enrolled in the manner that a money judgment could, but not that it couldn't be enforced through some more, wholesome action. That you couldn't
Well, that was
sue
going to
to
be my
enforce.
question. Is that what it meant? Because I think at the time I read it, I didn't understand what his point was. It couldn't be enrolled, but it could it have been enforced? Could you have gone to the California court with the judgment of absolute divorce and said
And
to
then-
the California courts, look, here's this judgment. She was supposed to pay me money. She didn't do it. Please enforce this. Could you have done that?
I don't know if the California court would have felt that it was in their jurisdiction to then enroll a money judgment based on a District of Columbia.
Well, what I'm
Order
asking,
to
is
pay
that
money
what the
with it.
lawyer opined on? Did the lawyer
No, that
say,
did not
no,
opine
that can't be
specifically
done?
on that issue. It was very limited that he attempted to roll the judgment of absolute divorce because it is a judgment in California and they would not allow it to roll, and that the appellant took the position that it could not be enrolled in California, the Sister Judgment Act.
Yeah, but I'm not sure exactly how it works in California, but we don't use the word enrolled. Usually we use the word registered.
Yes,
But I mean, in DC, so it might be that you're more used to California lingo. But when you have a money judgment, what you get to do is you get to walk into the Superior Court, you get to slap it on a clerk's desk and they stamp it and they say, that's a lien. You're done. And then if the other party wants to initiate court proceedings, the party who is, in this case, it would be Mrs. Block, they kind of have to affirmatively interpose defenses against that and say, I don't actually owe this amount. I've paid them. They forgave the debt, et cetera, et cetera. And that's how the proceedings are going. So I understand your legal expert to be saying, well, you couldn't have done that with the 2011 order in California because it's not a money judgment. I agree with that. But that's not an opinion but you could have filed your own action in California and said, hey, California court, I have a judgment from DC. It's not a money judgment, but it's a legally binding judgment that they owe me money that they haven't paid. And that just kind of becomes a matter, it's really a very similar to proceeding to if Ms. Block had interposed defenses, except that it's on you to initiate the legal proceedings instead of on them to interpose defenses to an enrolled judgment. I kind of see it as 6 on one hand, half dozen on the other. But I'm not sure which one is the appropriate mechanism. It is a little bit weird what Judge Becker did here. And it does seem more natural that you should have shown up in California Superior Court and say, I have a legally binding judgment. I can't enroll it / register it, but I can ask a court after an evidentiary hearing to enter its own money judgment that I can then enroll. But you're telling me you don't think that would have worked in California?
I don't think that would work, and I don't think the record in this case supports that because there's nothing was provided by the appellant that they would accept the enrollment. In fact, they've been litigating whether it was able to be enrolled or whether or
Why do
not.
they have to accept it?
Well, but they do have to accept that in order to pay money. I mean, yes, they would accept it, but there's nothing to enforce yet because there's no money judgment. So they would have to then somehow
But
determine.
that's just
that's-
one avenue.
No, I understand, but the court in California would have to accept that. And if they had accepted it and said, we will take jurisdiction to determine whether we enroll a money judgment, then Judge Becker could take a balancing test, but that didn't occur. What occurred is that a court that actually issued the order was asked to enforce its order, which is the court that has the ultimate jurisdiction and the ultimate paramount duty to enforce its orders. That's what the purpose is. We don't know what California would do. That's speculative.
It sounds to me like this argument, a different way of looking at it. Is, well, that's one reason why the case shouldn't have been kicked out on forum nonconvenience grounds. The real place this should have been litigated, defenses and all, was in the district. That's where the judgment was. It got before the judge who, if Ms. Block wanted to interpose some defenses to reducing that to a money judgment, she had an opportunity to do that.
And she didn't.
I appreciate that if that's the point, but then I wonder why your argument isn't, and I guess your answer is because you didn't file a counter appeal, that Judge Becker's order shouldn't have included all this business about potential defenses, which they could, I'm quite sure, raise in California against enforcement of the judgment regardless. But you're not making that argument because you didn't file a cross appeal.
Correct, but I do agree with your analysis. And I don't think she should have dated to stay, but I also agree that they could have interposed defenses they had in California based upon, subsequent contracts they may have entered into and subsequent agreements they may have entered into. Those would be separate cause of actions, either breach of contract causes of actions or other types of things that may have occurred from their if there's an alleged subsequent oral agreements between the parties, that could be litigated and still can be litigated out in California. It's just taken a very long time just because of we went through COVID and there were other procedures that this was becoming, we needed to get this thing moving. I think it was in the courts, for years before we were able to get, the final judgment. So at this point, we just want to be able to move forward and litigate it to the extent they raise any factual defenses in California, they're free to do so.
In your view, as you read this judgment, what happens if everything moves to California, exercises jurisdiction and says, we don't think this judgment should be enforced against Ms. Block at all? What's the next step? Because as I was discussing with your opponent, this order says that the California court may lift the stay if it determines to enforce the judgment against Ms. Block in whole or in part. Suppose it decides that her defenses are all valid, she shouldn't have to pay this money at all, then what happens?
Well, the judgment is stayed in this court. So if they decide it's not valid, that order would be brought to this court and the court would then
Then the court
give
would
it
do
good
whatever.
full
it
faith and
thinks
credit and
should
remove
do.
it. It's not like this case ends or jurisdiction of this court ends to modify this order since it's been stayed, the jurisdiction of court. So if for some reason California says this order is subject to valid defenses, we've ruled in favor of the appellant and find that all are part of it, all they have to do is bring that order to DC, be registered, and there'd really be, it'd be almost a ministerial task at that point for the court to just issue in a modified order. Because it's stayed, it's not as if it's an enforceable order at this point until those issues are litigated in California. So it'd be very easy it doesn't harm the appellant by having it being entered and the defenses being raised in California. Since it's not being attached, nothing can happen to it. We can't take any collection actions. And this jurisdiction of this court remains to modify or to completely extinguish it based upon the ruling in the California court.
So having to spend more money to come back here for a third proceeding or whatever number we're up to, you don't view that as any kind of harm?
I think that would be pretty minor and compared to all the proceedings that have gone on. The litigation in California, which has been attached to the pleadings in this case where it got dismissed. And there's already currently a pending case in California. And this case is to have, for the amount of money we're talking about, the amount of procedure we've gone through in the last 4.5 years on this issue. I think just coming back with a simple, here's the judgment of the California would not really be much of a burden.
So tell me, what harm would it have been, or would it be any harm to your client if the court had entered a Mills style judgment and had revived the DC judgment so that there was for sure another 12 years? We knew execution could issue on it in DC per the other pieces of code, and said, we are going to send this and our judgment is conditional. If California does not take jurisdiction over this and adjudicate it, we are still available.
One, I think it delays the process because then we come back and have to litigate the exact same issues that are in California.
Why would you have to come back?
Because of California, we don't know, there's no evidence that California would take it. You know, California would accept it. It's being litigated now because it's based on a money judgment. We don't know that what California would do with an order to pay money, not a judgment issued by a foreign jurisdiction, whether or not the court would then say, okay, we have the inherent power to order a judgment that DC chose not to. DC, the jurisdiction that issued the order to pay money in a judgment of absolute, chose not to issue a money judgment that somehow we
Well,
have
that case wouldn't
inherent
be
authority.
DC choosing not to enter a money judgment. It'd be DC choosing to ask California to look at it, right? I mean, are you saying that California's common law and then codified procedure to give full faith and credit to judgments outside of California is somehow defective?
This is not a judgment, so full faith and credit would not apply to the,
I mean, this is
Order
a
to pay
judgment.
money.
So you're saying a divorce decree is not a judgment?
it is a judgment, the judgment of absolute divorce, but it's an order to pay money is not a judgment. That's separate, and there's case law that says that that is not actual in order to pay money.
I mean,
by
it says
itself.
it's not a money judgment,
Yes, so
but it is a judgment. It's actionable by a court.
well, I don't know if, because it's something that happens in the future, whether it's actionable by a court without it being changed into a money judgment.
Fair
And
enough.
and the court that issued the order is the court that I believe, and I believe the case law says, is the one that has the paramount interest in enforcing the orders it makes versus a foreign court choosing to enforce orders of the District of Columbia.
All right, thank you, counsel. Unless there are any further questions from my colleagues, we will give them some time for rebuttal.
Thank you. First of all, I just want to point Justice Thompson to A614. I believe that's the affidavit that you saw in the record, and that is not the affidavit that Mr. Costeca was referring to. That is the affidavit in which Mr. Block's California counsel essentially says that once the judgment is enrolled in California, the California court cannot modify that judgment. Okay. Mr. Block's counsel continues to conflate two different procedural routes. Right? There's the ability to sue on a judgment. He could have sued in the civil division on the judgment to get post-judgment relief. He could have taken that judgment because they both were living in California and under full faith and credit, asked the court to enforce the judgment, not as a contempt proceeding, but simply because there was a judgment entered by the Superior Court of the District of Columbia requiring money to be paid, $2,083,000 in 2012. I wasn't paid. I want judgment for that. She didn't comply with the court judgment. That is available. That's always been available. What Mr. Block has insisted on doing is to treat this as the $2,083,000 as a money judgment that he wants to unroll. Different procedural path. I think Your Honor has, kind of pointed it out. In that case, the judgment's enrolled and the burden then shifts to Mrs. Block to say why the California court shouldn't enroll the judgment, right? It's a judgment, it's of record, and she now has to challenge it. But he always had the path, always, to sue in California on full faith and credit. There's nothing, it's a constitutional mandate. So there's nothing unique about California there. What happened, and this is important, Mrs. Block didn't waive any defenses. We had our initial proceeding before Judge Leibowitz, and she said, look, this is a post-judgment proceeding. You are not procedurally asking for the right type of relief, right? There's a final judgment of absolute divorce. Okay, if you want a different type of relief, you have to come in with a different type of procedural vehicle. Typically being, you could file a complaint in the civil division asking for a judgment for non-payment. You probably, because the divisions don't matter, you could file something in the family division. Maybe you could even have filed a post-judgment, but she dismissed it. He came back with a petition for contempt. Mrs. Block moved to dismiss the petition for contempt because It's well settled. They, in the District of Columbia, you cannot hold somebody in contempt for failure to pay money. That is not contemptuous. You can't get a contempt order. Again, it's not my job to help Mr. Block figure out how to get the relief he wants. I just was pointing out to the court, contempt was not the right avenue. When we appeared before Judge Becker in March 14th of 2022, the transcript's in there. You can see the back and forth with Judge Becker and myself, much like today's back and forth, where she's saying she wanted to just cut through the procedural and she just wanted to know, do I have any authority to grant Mr. Block the relief he seeks? Forget about what we call it. I don't want, like, don't get hung up on, right, form over substance. Just, do I have the relief? And Mr. Lowinger, I want you to brief it. And then she issued an order where she also asked me to brief a specific section, a specific rule. Now, which goes a little bit to your question, which did Judge Kravitz essentially stay entry of the judgment as to the 2,000,083, so the court retained the power to do something, to enter a money judgment. I ultimately came back and said, courts always have the inherent judgment, the inherent jurisdiction to enforce their orders. So you have the, I believe it was like an 18-something case. Of course, you have the authority to do something. Now, on the March 14th hearing, she said to the parties, if I decide I have the authority to do something, there was no dispute because my brief said you have the authority, right? We're gonna have an evidentiary hearing and Mrs. Block is gonna present her defenses. We never got there. Okay, whether or not Mrs. Block was going to assert any defenses, whether essentially the motion to dismiss the petition for contempt was denied.
Yeah, but I thought Ms. Block's point was that this is not the convenient forum to do that. I mean,
No, that was the court raised that issue.
you didn't raise any forum nonconvenience?
No.
Grounds? I thought the parties were in general agreement over that this would be better litigated in California. Did you ever say that wouldn't be a good idea, Your Honor?
No. So procedurally, what happens was she asked us on March 14th just to say, do I have the authority? I will say this. When I briefed it, I dropped a footnote and said, you know, the court does have the authority, whether or not it's the right jurisdiction, forum nonconvenience is an issue for another day. I'm not raising that here. I dropped it in a footnote. She raised it herself. That's what happened. She just.
I mean, a comment you made earlier really struck me, which is this is really the ultimate case of form over substance. The truth is, Mr. Block is owed $2 million by virtue of this 2012 timeline that gets triggered. Mrs. Block has some defenses she would like to assert.
Right.
The parties, so far as I can tell, seem to agree those defenses are best adjudicated in California. And the money judgment, reducing the 2012 judgment to a money judgment is something that seems more in the wheelhouse of the DC courts because it's enforcing its own judgment. So I appreciate I'm not sure that Judge Becker did the right thing, or that what she did is the precisely correct thing. But it does strike me as a very practical way of putting the parties out of their misery on this. And not let the lawyers steer this through a procedural mess any longer when we all know where this is ending. And it's ending on whether or not Ms. Block actually has any defenses to this judgment. And that's something that's probably best litigated in California courts. So what harm is there to you in the order that she's ultimately issued? Like what is your real complaint other than sort of a technical one?
Actually, for me, if you look at the way after the judge announced her opinion as it first unfurled, we weren't complaining to go out to California. It's that affidavit that triggered the problem. It's the inability of the California court to modify the DC judgment. But for that, no problems at all. Zero.
But forget the affidavit because the DC court's own order says feel free to disregard what I'm saying if you rule for Ms. Block.
I'm sorry,
I thought
the DC court said that the California court is to consider all claims and defenses and then decide to, as the court points out, to lift the stay in whole or in part, right?
And if you have to go back to DC, it's going to be a 5-minute hearing. You know, once California says something, And they say, oh, actually, she doesn't owe any money. You come back to Judge Becker and that money judgment's going to be out the door. That's not going to, I guess I don't understand why. What interests are being advanced right now?
Okay, so well, I don't want to muddy the water anymore, but as it turns out, right? This is like Bleak House. It turns out that technically California cannot enroll a state order. Right? And so procedurally, they're out there wrestling with what they can do because the DC order has been stayed, hasn't been entered. Right? So the Sister State Act, one of the exceptions to enrollment is that the judgment not be stayed. And it is. So I can't weigh in on what's going on out there. My concern for my client is not that it's going to be 5 minutes coming back to DC. Yes, that's obviously a bit of a concern. But remember, the judgment is sitting in California. It's been enrolled in California. And unless the California court is going to have the authority, and the only thing in the record right now is what Mr. Block's counsel said, is that they can't do anything to the DC judgment. Can't modify it. They can't revise it. That's what his counsel said. That's the problem. Therein is the rub. Other than that, I'm fine with the pragmatic resolution, right? The evidence is out there. Parties are out there. You know, we don't have to get caught up between, you know, should he have sought full faith and credit or enroll? Like originally Mrs. Block, and you'll see this, she was willing to accept the pragmatism of the court because it made sense, but for that problem. And I don't think, and I've cited it not in our brief, but I've never done it. The ability to come back years after the fact and then ask the DC court to revise a judgment because it's obviously at that point, it's going to be well past the revisory period based on what California did. You say it should be 5 minutes, and I hope so. But that's the problem.
I would think, given that the judgment was stayed, that there's not going to be any encumbrance on a revisory period.
The action was dismissed and execution was stayed based on a California court doing something. That's it, right? She courts to dismiss the action and stay it. That's the whole point. It's the hybrid nature of what she did. Now, you may be right because the stay, she's got to stay. The court may have jurisdiction to revise its order. I think there's a rule out there, which I've cited in the brief, that you could probably use as a way to do it. But I'm not sure where that leaves you with the California judgment. You might get relief in DC, but you have to go back and attempt to enter the new DC judgment.
I agree. It's all quite odd. It is an oddity that seems to me the parties might be able to smooth over amongst themselves. And it's because we all, I think, know where this is landing. But unless my colleagues have any further questions. All right, thank you, Counsel.
Appreciate the court's time.
We'll take it under advisement.
Have a nice afternoon.
Thank you.
The court will next call case 23 FS 981 in re petition of MVM and JAN VF appellant.
But I took a mask off, so I can
Sure.
talk. I'm sure everyone I not contagious. I just have really bad allergies and asthma, so.
Very good. You know,
Contagious, I promise.
Ms. Pereira, before you begin, can I ask, are the appellees, how are the appellees planning on splitting their time? Just so I know.
Starting at 11, splitting time, up at 6.
Understood. Thank you very much.
Do you have some water? No.
I'll have, it's just asthma. I have to, a 42-year-old that has to take a inhaler in the morning during this time of year, so bear with me. Sorry, court's indulgence for one moment. So I guess I will just start with the crux of it. We believe that in this case, the court erred when it found by clear and convincing evidence that Brandon Foss was an unfit parent. We also believe that the court erred when it found that it was in the respondent's best interest for Mr. Foss's parental rights to be terminated, and that he was withholding his consent to the adoption contrary to the best interest of the respondent. There, in the District of Columbia, there's a strong presumption that the respondent's best interest will be served by placing him or her with the natural parent, providing the parent has not been proven unfit. There's a list of factors.
Can I just interject there?
Sorry.
The district says that presumption doesn't apply here because your client wasn't seeking custody. Do you have a reaction to that?
I think that in any situation in which the perhaps it's a distinction without it's not really a valid distinction. I mean, in this situation, he's effectively seeking custody of the child. I mean, he may not be technically have filed a custody motion for custody or petition for custody, but he was essentially effectively wanting custody of the child. And so I think that the presumption would apply regardless of whether he's actually filed formal documentation for it or whether he is sort of, in fact, seeking custody.
I mean, there's physical custody and legal custody, right? And was your client seeking physical custody? My understanding was no.
Well, he had not filed a petition for custody, but he
Did
would
he
have.
express an interest in taking the minor into his living situation and caring for him? You know, the things that we would typically refer to as physical custody.
Sure. He was certainly interested in working towards a situation where he could take the minor child into, I mean, that was sort of, I guess, what the case was about, is establishing a situation where he could take custody of the child, take the child into his living situation, care for the child.
And he did express plans, right, that he would allow the prospective adoptive parents to visit with the child at parks and things that would implicate an intent for physical custody.
Right, that was sort of going to be my next point, is that he did express interest, or he did indicate that he had plans, you know, that the child was, he would make sure the child attended the same pediatrician, that he would always be a phone call away, implicitly that the child would be a phone call away from the petitioners, that he would ensure that the child was able to see mom and mom's family as well. And so I think that you know, while maybe not a sophisticated articulation of wanting to take the child into his care, I think we can imply that he did want to take the child into his care, and that he expressed plans and was working towards remedying the identified goals that the court had identified for where he could reunify with the child.
What is the evidence that your client was working toward remedying his problem of homelessness? He was in a shelter, right? And he, according to the briefs, he declined assistance from CFSA in helping him to locate housing. So what was the evidence that he was trying to do that?
Well, Your Honor, he was working with he had several sort of service providers in place, and there was one of when, through his, I believe it was, Abundant Grace. I believe there was housing assistance through Abundant Grace that, where he was. And I think in even one of the medical notes, he had indicated that that was something that he was working towards. So I believe it was through them that he was working on housing, remedying the housing situation. You know, that was obviously one thing that was still outstanding. But I think when we look at the entire case, I mean, there were, he was doing other things to work towards remedying the situation. He was participating in mental health, or engaging with a mental health provider. He had established paternity. He had participated in evaluations. He was visiting with the
Counsel,
child.
was there a point, as I was looking through the record, I was trying to figure out, while he was definitely engaging with mental health providers, was there a point that he stopped refusing to take medication and started taking it?
Your Honor, I think that the record is clear based on the records that he was not taking medication. I think that certainly whether or not somebody takes medication is probably something that they have to work with their providers to figure out if it's the right situation. I mean, you know, not everybody wants to take medication. And so while it was something I believe the record indicates was recommended through evaluation, he was not taking medication. I think that there might have been a brief period maybe where he was, or where he indicated that he was willing to, but he was not. But he was engaging in other services through the mental health provider.
I mean, there's engaging in services, but usually sort of trying to take some steps toward becoming a fit parent is not sufficient unless there's actual progress happening. So when we talk about, you know, working with potential housing assistance, this neglect case started in 2021. And this order is issued 2 years and several months later. I mean, has he made any progress? Forget about working with people. Like, had he gotten any closer to having stable housing? Or had he gotten any closer to getting his mental health issues under control?
Your Honor, I think progress is probably a difficult thing to really ascertain. I mean, admittedly, he was still homeless. I think that housing is a problem in the city. So, he was still homeless at the time. I mean, I think that's just, there's nothing else to say about that. I mean, there's really nothing else to say about his homeless situation. He was homeless. He was working with providers to try to remedy that situation, but he had not acquired housing. And I think that it's just a difficult thing for people to be able to do, particularly in an expensive city.
No, I had thought there was some evidence, at least according to the trial court's order. Maybe you'll tell me if it's wrong, that he was refusing housing assistance because he didn't need it, because he had some homes that were being built for him in Virginia. Which is sort of speaking to a mental health issue. That his mental health issues were prompting him not to accept housing assistance, and neither of those situations have really been addressed. It's sort of what the trial court is saying, and I'm just wondering what basis you have for saying there's insufficient evidence supporting that.
The basis that I have is that he had indicated that that he was working with his providers to acquire housing. There did seem to be an acknowledgement that he needed housing. I think there were several points where he's indicated, well, I need housing so that I can have my kids. So my interpretation is not that he was refusing housing assistance because he believed that he already had housing. My recollection is that he was indicating he needed housing, and that he was working with people, with his providers to acquire housing. And I believe that even in the beginning of the case that he indicated that he couldn't take her at the time because he didn't have housing. So I think there was always an acknowledgement that he needed housing. There were times that he indicated he was, I believe that he had housing in Virginia, but I don't believe that he ever refused housing assistance because of this assertion.
I guess it really comes down to what is the reasonable time within which he needed to be able to provide for the well-being of the child? Because, I mean, your arguments sort of quite rightly reflect an acknowledgement that our case law doesn't say to be fit, you have to be fit this very moment, but they talk about being sort of situated so that in the within a reasonable time, you can provide care for the child. And I guess what I'm not seeing is what in the record suggests that the trial judge and the reviewing judge sort of cut off his time prematurely when they weren't seeing progress on any of these fronts. Is there anything you would point to that would suggest that they were just sort of premature in determining that he is not fit to parent this child?
Well, Your Honor, I would just point to the fact that he was taking steps, that he was visiting with the child, he was establishing a bond. And, you know, this was not somebody that just said, no, I'm doing nothing, which I think that, you know, that perhaps the time frame would be more appropriate for that. I mean, he was taking steps, he was taking actions. You know, the child was very young still at the time of the trial. I believe she was around 2 years old. And I think more time would have been appropriate for somebody that was showing that they were willing and able to take some steps and had established the importance of a bond and showed a willingness to still have the child engage with sort of these important people in their life, including the foster parents. You know, when we talk about, you know, an adoption that would basically sever his rights to the child, his engagement with the child. And we have a parent that is willing and showing effort towards essentially staying in the child's life. More time. I mean, I can't say exactly what that time, I mean, I don't think it's spelled out anywhere what reasonable means, but it seems that somebody who is participating actively up until sort of the month of the trial is engaging with the child, is taking steps, is showing a willingness. And when we look at what the flip side of that would be sort of a permanent severing of that relationship with him and the child, that it would be premature. So that would be my answer to that. Have any other questions?
If there are no further questions, we'll give you the remaining time on rebuttal, unless you have anything you want to wrap up with.
No, that's okay.
All right, thank you, counsel. I will hear from counsel for, I get the GAL.
That's correct. Good morning, Your Honors. Catherine Pigatuk here, FLE on behalf of LK, the minor child. The court should affirm the judgment below because the lower court did not abuse its discretion in concluding that BF was unfit to parent LK and was withholding consent to her adoption contrary to LK's best interest. Now, briefly, I'd like to just start with the ATJ question. We disagree with the government's assertion that the parental presumption shouldn't apply in this case. We do support the adoption, but just a few quick thoughts on that. First, there's a forfeiture issue here. Nobody raised this below, and the trial court did not grapple with this question in any way. What we do have the trial court grappling with is the trial court did a fulsome analysis here, went through the constitutionally required fitness analysis. So we have a strong record. And so answering that question just isn't necessary for this court to do today. But just one final point on that issue. There's just not clarity on this record about what this father was seeking, and that he wasn't seeking some kind of custodial relationship, some kind of parenting responsibility. And so without that lack of clarity, the court shouldn't stretch to apply ATJ and not allow him the constitutional inquiry into the fitness. There wasn't clarity both in terms of what he wanted, except that he said that he did want visitation. That was clear. And visitation, custody can encompass a wide range of scenarios, including legal, actual, sometimes a parent that might have just periodic visitation. And so again, we think with the lack of clarity about what he wanted, and then also the lack of clarity at the trial court about whether the trial court should do this full analysis, and that the trial court in fact did do the full analysis, the court shouldn't reach that question today, or if it does, should not apply ATJ. Turning to the fitness issue, just briefly, the record showed that BF had a very limited relationship with LK over the course of her life. She never lived with him, going straight from the hospital into foster care, where she lived for 2 years. During that time, he did not visit her consistently. And during the visits he did attend, he had minimal engagement with her and did not do any type of caretaking, provide any tangible support. And at base, he just didn't have that caregiving relationship with her, either before removal or throughout the case. In SLG, this court highlighted that a parent's failure to maintain contact with, nurture, or support a child can be a basis for unfitness, and the record amply supports that conclusion here. Additionally, the record showed that BF had significant chronic mental health illness, a diagnosis of schizoaffective disorder, bipolar type, numerous accounts of delusions and hallucinations that never improved, because as was discussed earlier, he never took medication and he never went to therapy. Expert testimony, uncontroverted expert testimony, established that his mental health issue impacted his ability to care for LK. So under SLG, the court did not abuse its discretion in determining that BF was not able to provide for LK's well-being or meet her needs, either at the time of trial or into the foreseeable future. This court asked a question about time, how long he should have to establish that he's able to become fit. And here, I think the most salient point is that he had not gotten closer. He had not engaged in any of the meaningful steps to start to become fit. And so the court did not abuse its discretion in determining that he would not become so in the foreseeable future. In addition, there was ample evidence on the record to support the court's conclusion that BF was withholding his consent contrary to LK's best interest, both by the facts already discussed today and also by the evidence of LK's close, loving, and familial relationship with the petitioners, the people she had been thriving with in their care for her entire life. If the court has any questions, I'm happy to answer them. In that case, we rest on the arguments in the brief.
Thank you, counsel. We will hear from counsel for the District of Columbia.
Good morning, Pam Sanchini on behalf of the district. Unless the court has any questions today, particularly on this issue of ATJ, the district is prepared to submit on the briefs and the well-reasoned opinion of the associate judge who affirmed the final decree here.
Well, I guess I had the same reaction as the GAL to that argument, which is it wasn't made below that there is no parental presumption. And so what's your reaction to that? Why isn't that argument forfeited?
So the district did acknowledge in its briefing in the footnote that it wasn't raised below, but asked this court that putting forfeiture aside, the issue could be addressed because the facts have been developed and the appellant had an opportunity to address the issues in a reply brief, which she did not.
That's so funny. The district, I have two cases with you guys today where you're sort of doing this. Just forget the fact we didn't argue it below, which is usually not the position that you're taking.
Correct.
So one point that the GAL makes, which I think is a pretty good one, which is it's not really clear what appellant was seeking in terms of custody. Seemingly, I couldn't tell. Physical custody, maybe legal custody. And so not only is there sort of the legal question of whether or not this argument's been forfeited, but then there's even if we sort of have this authority, as I previously referred to it, to sort of willy-nilly overlook a forfeiture, this would be a very strange case to do it because you would want answers to questions like that the magistrate judge certainly would have probed further if this argument had been made, and we just don't have them. Why isn't that a pretty strong reason not to whatever extent we have authority to overlook a forfeiture? Why isn't this a really bad case for doing it? Because of that lack of factual development on a pretty critical piece of it. If you can follow that, I know it's a lot.
Yes. Certainly there wasn't a factual development, but I do think that BF was consistently expressing that all he hoped for was visitation, which is consistent with his behavior throughout the case. He was never seeking to assume any parental responsibility, which is what the parental presumption is meant to protect. It protects not his biological relationship, but his desire to be a parent to the child, which he never He never actually expressed any desire through his actions, through his compliance with court orders. During his testimony, he repeatedly said he wanted to visit. When he talked about maintaining contact with maternal relatives, he responded by saying, well, sure, when she's with me on a visit, we can call them. He spoke consistently about wanting visits. Adoption is a good thing. He's adopted himself. When he expressed a desire during closing arguments to consent to the adoption, it was understandable that at that juncture, the court expressed hesitation. But I don't disagree with the guardian ad litem that in this case, there's ample evidence to support his unfitness, and the court can affirm the judgment based on that.
I have one other quick question for you, going back to the timing piece again. In really every other case I've seen in the family area that's similar to this, someone typically has around 2 years of being found not fit or not making progress before we move to this step. And I understand that the adoption petition came earlier in this case, and that may be the answer, or also the answer we've already heard, that progress just wasn't showing up. But is there a reason or something that you could point me to as to why kind of this 2-year standard that I remember being addressed in another case was not applied here, and instead it was kind of at the 18-month point that we decided to move on?
So the statute there's 2 places in the statute that require the court to reach this question by this point. 15 out of 22 months is required to file a termination of parental rights motion that's set by federal statutes. And by the first permanency hearing, which is held roughly 15 months, again, it's 12 months from entry into foster care, the court has to address a permanency plan. In this case, the court did do that in February of 2022, which was a little bit, I apologize, by February of 2023. So it was a few months shy of that, but the court had consistently found at every review hearing without objection from appellant that he was making no progress towards a reunification. And by the time the court held the adoption trial, the child had been in care for nearly 2 years.
Thank you, counsel.
Thank you very much.
Ms. Pereira, we'll give you a few minutes for rebuttal if you'd like it.
Yeah, just a few things, just to clarify, or I guess to point out. As to the fitness argument, I believe it was the JL indicated that Mr. Foss did not, he did not engage as a caregiver. This wasn't a caregiver relationship. And I would just like to point out it's somewhat of, I don't know, a circular argument, because, you know, the child had been in care since she was born. And so I'm not sure that, I guess to say fair is the wrong word, but I'm not sure that it's really an appropriate assessment of fitness to sort of evaluate it in this way, that he was not a caregiver. I mean, he showed up, he brought items, he took her to parks. I mean, I think that those are caregiver things that caregivers would do as well. I would also say that, you know, the focus on him saying that he wanted visitation. I mean, he did say those things. He also indicated that, you know, was making plans to have the children with him. He was indicating that he needed housing so that, you know, that his children could be with him. And so I think to hold him to just the comments about wanting visitation and that he expressed in the context of it, you know, hearing or trial that he may or may not have felt was sort of going his way, you know, is not, I don't think that that's how it should be. His plans with regards to custody should be evaluated in that way. I mean, he said different things about custody, or he never said custody, but he said different things about having the children. So I just wanted to point those things out. So that's, I rest.
There's nothing further. Thank you, counsel. We'll take it under advisement and the case will be submitted and the court stands adjourned.
All right. This honorable court is now adjourned.
Same here. So.